Funding for this firing line debate was made possible by a grant from the John M. Olin Foundation, Incorporated, the Annenberg Foundation, and the Laurel Foundation.
From the George Washington University in Washington, D.C., welcome to a special firing line debate. This is the 175th anniversary of the founding of GW, and we're delighted to be part of the celebration of that occasion. Our topic this evening is, Resolved, the new anti-terror bill is good for Americans. That title refers to anti-terrorism legislation currently before Congress. After the Oklahoma City bombing in April, which killed 168 people, an anti-terror bill quickly passed the Senate with the support of President Clinton. Similar legislation has been approved in the House Judiciary Committee, but the bill has been stalled on the House floor by an unusual coalition of conservative Republicans and liberal Democrats. Both groups are concerned about the effect on civil liberties and constitutional rights. The bill would authorize several $1 billion for new FBI agents and equipment. It would expand penalties for terrorist crimes, including the death penalty. It would create a special court to deport aliens suspected of terrorism. It would forbid groups designated as terrorists to raise funds in the United States. The bill would increase military involvement in domestic law enforcement. It would broaden the permissible use of wiretaps on terrorist suspects. And it would place new limits on appeals of death penalty sentences, not just for terrorism, but for all crimes. Is all of this a reasonable and measured response to a real threat? Or are we sacrificing our own freedoms out of excessive panic over terrorism? That's the debate. My name's Mike Kinsley. I wield this gavel. Now let's welcome tonight's distinguished debaters. The captain of the affirmative team, naturally, is William F. Buckley, the host of Firing Line, the founder of National Review, the author of books and articles too numerous to read, too numerous to mention. Mr. Buckley has set off many a bomb in his day, but only of the intellectual variety. Senator Arlen Specter, Republican of Pennsylvania, has served in the Senate since 1981. Before that, he was District Attorney of Philadelphia. He also served as Assistant Counsel to the Warren Commission investigating the assassination of President Kennedy. So he is well informed about international terrorist conspiracies of all sorts, both real and imagined. Senator Specter is a declared candidate for President of the United States. Victoria Toensing founded and ran the terrorism unit of the Justice Department under President Reagan. She also served as chief counsel of the Senate Intelligence Committee under the chairmanship of Barry Goldwater. And before that, she was a federal prosecutor in Detroit. She currently is a Washington lawyer specializing in the defense of white-collar crimes. Of course, the defense of people accused of white-collar crimes. Stephen Emerson is, what? I do my best. Stephen Emerson is a journalist and broadcaster specializing in terrorism, by which, of course, I mean specializing in reporting on terrorism, especially involving the Middle East. Most recently, he was executive producer and correspondent for a PBS documentary called Jihad in America. He has written 4 books and numerous articles on Middle East terrorism and related issues. Almost as unsurprising as the captain of the affirmative team is the captain of the opposition team. It's none other than Ira Glasser, executive director of the American Civil Liberties Union. On this issue, the ACLU finds itself on the same side as the National Rifle Association. That's certainly a case of strange bedfellows, but then who better to defend strange bedfellows than the ACLU? Professor David Cole teaches constitutional law at the Georgetown University Law Center. He also works at the Center for Constitutional Rights and writes a column for Legal Times magazine. He argued the Supreme Court's 2 most recent cases on the subject of flag burning, and needless to say, he was on the side of the flag burners, and he won. Isn't that right?
It's true that I won. It's not true that I argued. I represented the defendants, but my co-counsel, Bill Kunstler, argued the cases in the Supreme Court.
But you won. I stand corrected. James Zogby is president of the Arab American Institute and former executive director of the American Arab Anti-Discrimination Committee. He is probably the country's best-known voice of Arab Americans on political matters. In addition, he is a member of the Democratic National Committee, and in 1984, he was deputy campaign manager for presidential candidate Jesse Jackson. Finally, Anthony Lewis is a columnist for the New York Times and twice winner of the Pulitzer Prize. His book, Gideon's Trumpet, is probably the most famous book ever written about the Supreme Court and civil liberties. Mr. Lewis is also a visiting professor at Columbia Law School, and for many years he taught at Harvard Law School, where a long time ago he gave me a B+, which was very generous. So those are the teams, and I now call upon Mr. Buckley to propose tonight's motion.
Mr. Chairman, ladies and gentlemen, what are we arguing about? The Senate of the United States voted by 91-8 in favor of the anti-terrorism bill. No doubt the Oklahoma explosion precipitated action. So what? Pearl Harbor precipitated action. The idea is that terrorists, whether foreign, as in the World Trade Center, or domestic, as in Oklahoma City, should be discouraged. If someone plans secretly to blow up the headquarters of the American Civil Liberties Union, that person should be detected and deterred. Most people would agree. The question, of course, is how? I personally concede that the Senate took advantage of the general anti-terrorist anxiety to throw in a modification of habeas corpus procedures. The motivation of the Senate here may have blurred the distinction between terrorist killing and non-terrorist killings, but their objective was to do something about reigning procedures, which have set aside an average of 10 years between the conviction of someone for murder and his execution. Habeas corpus is a cherished tradition, but so is the administration of justice. There is no more reason to allow 10 years between conviction and execution than there'd be to allow 10 years between the commission of a crime and the apprehension of the perpetrator. I and my colleagues believe that even as we hope that executions can be retributive, so we'd like to think they might serve as deterrents, to which end the provision in the anti-terrorism bill. What else does it do? It broadens federal jurisdiction over crimes linked to international terrorism, which is certainly sensible. It authorizes $2 billion over 5 years for additional equipment and for agents trained to combat terrorism, which sum of money is deducted from the midnight baseball crime bill of Mr. Clinton last year. The bill permits the military to cooperate with law enforcement in responding to incidents involving chemical and biological weapons, as the military now may do in cases involving nuclear weapons. Fundraising in the United States for terrorist-connected fronts would be less easy. Explosives would be traceable. And then there are provisions to expedite federal law enforcement agencies in conducting what is called roving wiretaps in terrorist investigations. This means practically that if an agent is authorized to tape suspect Abdul Bula at his hotel room, the tap is correlatively sustained to tap Abdul's telephone in his office or in his car. Perhaps most controversial is the provision for a special court charged with deporting suspect aliens, whether in this country legally or illegally. That court would operate behind the scenes, and defendants would not be entitled to the identical rights exercised by U.S. citizens. The premise here is that the culture of terrorism needs to be dealt with those extra weapons used in the world of spies and espionage and infiltration. And one of these is quite simply the withdrawal of a visa to live in America. In the 1970s, Prime Minister Rajiv Gandhi of India visited this country, where a terrorist faction plotted his assassination. The day came to pull the trigger, and the hitman was dispatched to proceed. It might have gone well for the terrorists, except that the hitman was a government agent. A veteran of Vietnam who had previously been awarded the Congressional Medal of Honor. It is activity of that kind that the bill seeks to encourage. We'd have been better off if, when petitioned to place a Foreign Intelligence Surveillance Act wiretap on Sheikh Omar Abdul Rahman in November '92, the FBI had felt it correct to proceed to do so. But no, by current standards, the threshold of evidence needed to be higher. The Justice Department ruled, and 4 months later, the World Trade Center bomb went off. Mr. Chairman, the affirmative contends that American citizens have a right to a defense against terrorism responsive to the nature of the threat of terrorism. Opponents of the bill have nothing more to tell us than that the Bill of Rights immobilizes serious anti-criminal legislation, as we will now reestablish after hearing Mr. Glasser's eloquent arguments in favor of doing nothing. Mr. Glasser, please show us how to do nothing. Thank you.
Mr. Buckley. Glasser to oppose tonight's motion. Mr. Glasser.
Mr. Buckley referred to the midnight baseball leagues, I guess, and it was the midnight basketball leagues, Bill, the first of many mistakes you will make tonight. Having taken you to your first baseball game a year ago, it really dispirits me that you don't even know the difference between baseball and basketball. My attempts for years to instruct you on things American, like baseball and the Constitution, both fail. But irrepressible though I am, I will try again. You mentioned that Pearl Harbor initiated action. It did. But one of the actions it initiated was the incarceration of 100,000 Japanese American citizens out of fear of national security, without any evidence that any of them were even suspected of a crime or of treason or of espionage. It was merely on the basis of national origin. Everyone now admits that that was a grievous mistake. But it would be nice not to make those mistakes when they happen. And we are about to make that sort of a mistake again. The lesson of that mistake is that when you're going after criminals, whether they're terrorists or any other criminals, you have to investigate, infiltrate, wiretap, do all that on the basis of criminal evidence, on the basis of real facts to believe that they are involved in a crime. There are if you don't do it on the basis of criminal evidence, then you have to do it on the basis of something else. And the something else always turns out to be political beliefs or associations. It turns out to be race. It turns out to be national origin. The principles we all ought to agree on that ought to shape this legislation is, first, that the FBI must have adequate authority to investigate anyone if there is a reason to believe that they are involved in criminal activity or planning criminal activity. Fact is that the current law gives the FBI all it needs. The director of the FBI admitted that on the record in congressional testimony. He sought no new authority. So why are we giving him any? The second principle is that although the FBI ought to be able to investigate criminal activity, it ought never be permitted to investigate people on the basis of political beliefs and associations. Those two principles are at stake. The current legislation that is pending, at least the leading bill in the House, badly blurs that distinction. If it passes, it would authorize the FBI to infiltrate, wiretap, investigate, and gather up a wide array of personal information, not on the basis of criminal activity, but on the basis of political association. It would establish secret courts that would be able to deport aliens on the basis of secret evidence that they have no fair opportunity to challenge. It would authorize the government to bar people like President Nelson Mandela of South Africa because he is a member of the African National Congress, which was once declared in the time of apartheid a terrorist organization. And it would increase the use of the military in civilian law enforcement, always dangerous. This bill, as many conservatives and liberals understand, would neither make us safe nor free. Current law protects our safety adequately and protects our freedom. The proposed laws will do neither, and all Americans who subscribe to American principles ought to oppose it.
Thank you, Mr. Glasser. Mr. Emerson and Mr. Zogby, it's your turn to ascend the podium. Come on up. And Mr. Emerson, you have an opportunity to make an opening remark.
First of all, I think I'm one of the only non-lawyers here today, so I will appropriately play one on TV. Terrorism is one of those buzzwords. It evokes fear, scorn, derision. It invokes anxiety. The fact remains, however, it's a phenomenon that has occurred and will continue to occur. It's the price that democracies pay for being democracies. The question before us today is whether democracies like the United States should subsidize the cost to the terrorists themselves as they wage war against the United States. It pays to remember what would have happened at the World Trade Center bombing had the bombers succeeded in toppling one tower onto the next, and releasing poisonous gas as they contemplated at the same time. In light of the fact that there were more than 50,000 occupants in both buildings at the time, casualties could easily have been 10,000 dead. And what about the second set of attempted bombings in mid-1993? The two Manhattan tunnels, the FBI federal building, the UN? Were it not for the successful penetration of the terrorist group, the casualties in that second series of events could have amounted to tens of thousands. The bottom line is that terrorism is a major threat to the United States today, and that U.S. citizens remain the disproportionate target, up to 40% of all international attacks. And as the acting head of the CIA testified in April before Congress, he said terrorists today are, quote, more dangerous and elusive. Quote, they appear to be aiming at mass civilian casualties. They operate in, quote, small cells without state sponsors. Please come in.
Thank you.
Let me just add one thing. The fact is, today you will hear the word McCarthyism thrown about more than any other term. And if McCarthy were alive today, he'd be a rich man if he got royalties. The fact is, McCarthyism has nothing to do with this bill. This bill has to do with the safety and protection of American citizens.
Okay, thank you. Don't go away. Don't go away. Mr. Zogby, it's your opportunity to make an opening remark.
Well, he might want to leave, and actually after a statement like that, he ought to leave. I find myself in the situation of saying, why am I here? In fact, there is a terrorist threat, not only in America, but around the world. The issue is it an Arab or Muslim threat, as Steve Emerson in much of his writing argues, based in some part on arguments made that a grave threat exists to America coming from the Arab and Muslim communities. Legislation has been offered that we feel, yes, would circumscribe the political rights of most Americans. But Arab Americans and Muslim Americans feel especially threatened, because while the measures proposed are in fact dangerous to the rights of all Americans, we have been targeted in the past by law enforcement and have become in fact the weak link in the civil liberties chain. When various administrations have attempted to rewrite extradition law or change the regulations used by FBI to intervene in domestic activity, etc., it's been done over the backs of our communities. Mr. Emerson has been riding a hobby horse on Arab and Muslim Americans and their activities now for a long time. 2 decades ago, he warned the Arabs are coming, meaning they were coming with their money to buy up America. And now it's the Muslims are coming. They're the terrorist threat to America. Interesting that he uses two images that are traditionally the anti-Semitic images used against Jews in the past, wealthy bankers or subversive anarchist terrorists. Today, the images used against my communities. The threat is there, but the threat does not come from Arab and Muslim Americans and does not require the draconian measures provided in this legislation. The sponsors of the legislation have assured us that we are not the targets, but we still fear that that is the case, and arguments too many have been made, including Mr. Buckley's reference to Abu Ghula, who doesn't exist, as a characteristic terrorist to justify this kind of measure.
Thank you. Mr. Emerson, this is your opportunity to question Mr. Zogby.
Mr. Zogby, the acting director of the CIA testified before Congress that transnational militant Islam today is the #1 threat facing the United States, and that they have cultivated support and recruitment in the United States. Do you accept that conclusion?
I do not accept that conclusion, and it's interesting, Steve, that you bring that up, because I just happen to have with me the statistics in chart form done by the State Department Office of Counterterrorism and the FBI. Here are the picture, if you will, the chart the FBI issues on terrorist activity in America over the period 82 to 92. Puerto Rican actions of terrorism, 77. Anti-Castro Cuban, 12. Special interest, mainly environmental groups and animal rights groups, 31. Jewish extremists, 16. Right-wing, 6. And left-wing, 23. Interesting, there are no Arab actions there. There are actually 2 that occurred in that period, and the third one, of course, occurring after that period, and that is the horrific bomb in the World Trade Center, which is important to note, and to note that all Arab American groups have denounced that action. In the State Department anti-terrorism record, Latin American terrorist attacks against U.S. interests or persons, 44, Middle Eastern origin, 8. In 1993, Latin American attacks against American U.S. interests, 68. Middle Eastern, again, 8. So yes, Steve, the findings are wrong, and I think that the acting director, he's the acting director, he's not the director anymore, and he's out, is wrong, very simply wrong.
Let's accept your statistics, and I accept them entirely as totally valid. Doesn't
why
this
are
mean
you on this hobby horse?
What's the the issue before us today is whether the counter-terrorist legislation is good for the United States. It's not the issue that you're trying to make it into, which is the issue that somehow American Muslims are being picked upon. You have made that the issue. I have never referred to as American Muslims as the subjects of somebody who should be investigated. I've always said very precisely that militant Islamic terrorists and suspects are the ones that should be investigated. Please let me finish.
Okay.
So assuming your figures are correct, and I accept them, there's a threat from Irish, from Latin American, from Jewish Defense League. Why not a counterterrorism bill to stop these attacks?
Again, I think that the record shows, FBI shows that there have been 1 or 2 acts at the most in the last few years committed in this country. Law enforcement has done an extraordinary job. We agree.
Wait,
Arab
now you're
American. Just let
praising
me.
law enforcement
You made
now?
a
You just
statement. Let me answer the
criticized law
question.
enforcement.
No, I'm criticizing the assessment made by the former acting director of the CIA. I'm not criticizing the ability of law enforcement to crack down and deal with the problem of terrorism. The fact.
Before you said that,
Steve, let me
didn't you?
finish,
Okay.
and it would be very polite. The thing is that, in fact, we have had law enforcement dealing with the problem of terrorism very effectively. We may need some refinements, and in fact, I would like to see some refinements in existing legislation. But the refinements proposed in the fundraising section, in the secret trial section, secret evidence section, in the draconian measures proposed in wiretaps and in other areas are too much, and the findings don't support them. But let me say, Steve, when you say a statement like this in front of a Jewish audience, the level of vitriol, I'm responding, though, to his argument that he's never said that Muslims were the problem. The level of vitriol against Jews and Christians within contemporary Islam, you said, unfortunately is something that we are not totally cognizant of or that we don't want to accept. We don't want to accept it because to do so would be to acknowledge that one of the world's great religions, which has more than 1.4 billion adherents, somehow sanctions genocide, planned genocide, as part of its religious doctrine. If you can argue from that statement
Mr.
that
Zogby,
you are
I can
supportive
see-
or sympathetic of Muslims,
Mr. Zogby, that
then
you
you
have
really
taken-
are constructing
Mr.
a
Zogby,
very interesting
your
artifact.
ability to read is almost as your ability to mix up the facts. The fact is that if you read that statement correctly and read the entire statement or heard the speech, you would have heard that I referred to militant Islamic networks. Okay, Mr. Zogby? You did not hear the speech.
doesn't say that here.
That's all right, because it's one of your militant Arab organizations apparently
No,
circulated
actually,
it.
it was not.
Yes, it was. No, listen, Mr. Zogby, the issue really is whether you will acknowledge, one, that there was a major terrorist threat, and that the World Trade Center, the second set of bombings, the Oklahoma bombings, should not be the ones that we face all the time and have to react to. The question is, do we have the legislative capabilities right now to counter it? And I say to you that you refuse to acknowledge the terrorist threat. When you talked on Nightline in 1993 about the bombings in the World Trade Center, you talked about their legitimate grievances,
No,
as
I
if
did not.
blowing up 50,000 people
Is he
had a
asking
legitimate
questions,
grievance.
or am I missing
No,
the
I
point
think
here?
you should be held accountable to the statements you've made.
I am held
and
accountable.
answer,
Let's
And
call
you've-
it a question.
you've
The
of
question
course-
and
is,
answer
did you say
why
on
you don't
Nightline-
think.
No, I did not.
Well, explain
Should I
why
read
not.
And you've
Should I read the
faxed
statement?
it all over town, but let me say,
Let me
Steve,
read it to you.
Can I answer the question?
Would you like
As I
to hear
understand-
it?
No.
You don't? Oh,
No.
I'm sorry.
I know what I said.
Okay, right.
The audience may want to hear it later. You'll have a chance to do so. But let me say, Steve,
I think they should
that
hear it
what's
now.
really interesting about you is the fact.
You know, something tells me I'm going to be nicely complimented right now.
No, actually, you're not.
I tell you what, it's your chance to ask questions of Mr. Emerson. That was Senator Specter's beeper going off.
Wait, didn't we just have Mr. Zogby asking questions of me?
Well, I'll tell you what, you can read your quote from Nightline, and then he'll ask questions of you. How's
Let
that?
me get the quote, and then.
But
you
I
can-
never did get to answer the question he was asking. And in fact,
I mean,
after that
he-
long
all right.
diatribe, I forgot what the question
You
was,
give
Steve.
us the
I
quote.
asked you the
answer
question whether we
and
should be
then you said,
reacting. You can answer the question. Should we, in light of the fact that the World Trade Center bombing occurred and the Oklahoma bombing occurred, and had the World Trade Center bombing been more devastating, you agree would have been. It was horrible. Would have been tens of thousands of
what's the
casualties.
question?
Question is, do you think we need legislation
Thanks for
to
reminding
stop that from happening again, or do we always have to be in a reactive mode?
No. Steve, reactive mode, when the World Trade Center bomb went off, you said the Serbs did it. When Oklahoma City happened, you said the Muslims did it. The fact is, you don't know the facts, and you're the one who reacts, and reacts wrongly. Let's say that we have a problem. We agree. The problem does not come from the Arab and Muslim community. We don't agree. The fact is, the issue that we ought to be dealing with is this legislation. And my point is that it goes too far, does too much, and is a danger to the civil liberties of all
now
Americans.
pose a question to Mr. Emerson.
With regard to the legislation, Steve, the section that deals with deportation of aliens, what would be wrong with tracking the procedures along the lines of current SEPA regulations, SEPA procedures?
What is SEPA?
It's the procedure that's used now in criminal cases that civil libertarians want to apply to as well these deportation proceedings. What would be wrong with that?
There's nothing wrong with it. What I'm suggesting is that today, because the nature of the threat has changed in the United States, and that you have groups that need to be infiltrated by informants whose identities and information cannot be disclosed, I think that the notion about allowing certain types of summaries of evidence against aliens should be permitted.
So
and that type of procedure is
secret evidence.
Well, there is secret evidence allowed today. In SEPA, which is the Classified Information Procedures Act, you're allowed summaries of information. So that is clearly allowed today, in addition to which...
But you're allowed to use that, but also the fact is that the defendant is allowed to see the evidence against them.
He's allowed to see the summaries. In SEPA, he's not allowed to see everything that's presented by the prosecution. Number two, the fact is, in current immigration...
But the judge cannot make the decision based on the secret
Please
evidence,
let me finish.
only on the summary.
In the current immigration law procedures today, a immigration judge, is allowed to hear hearsay evidence without disclosing the identity of the informant. So those types of, quote, secret evidence that you, I think, appropriately have concern for, it exists today. So we're not really talking about material change in the law.
In the legislation that passed the Senate, Senator Specter has offered himself some support for the section in dealing with fundraising that has been modified significantly over what it was originally because of the concerns of civil libertarians. You've criticized that. Do you want to explain why you criticized the resolution that passed the Senate?
I was critical of the fact that there was the legislative remedy proposed by the Senate took out the particular designation of domestic groups that are supportive of terrorism. I believe that the problem, and I agree with the head of the CIA in April, and I believe with the head of the FBI and the Justice Department, that today in the United States there are unfortunately many groups that support international terrorism. They use the cover of, quote, charities, quote, civil rights groups. They masquerade under these 501c3s when in fact they are really supporting terrorism. And I believe it is incumbent upon the American public to know exactly which groups are doing what. There should be truth in advertising. And if a group that is getting a 501c3 status or tax-exempt status is actually supporting terrorism, the United States should ban that group or list that group and make it prohibitive to make contributions to that group.
Existing legislation provides for criminal action against groups that raise money for criminal activity, for terrorist activity. Why do you want to extend that to include humanitarian activity as well?
The problem is that money is fungible. That's a fact of life.
So if you give money to a hospital,
You
that would then somehow
You yourself have
defray-
criticized the money that the Jewish Defense League and radical Jewish supporters have given to the settler movement in the West Bank that supported the killer Baruch Goldstein.
Of course, I criticize it if I
That's
wanted
right.
to
But
make it
money
illegal,
also, but
if
money
I wanted
also,
to put people in prison for it.
Please, money also goes to their, quote, charitable purposes as well as terrorist purposes.
What
I
charitable
agree
activity does
with
Meir
your
Kahane
statement.
engage in?
Please,
or did he engage in, God rest his soul?
They claim they engage in other support
Name
types
it.
of educational
Which
services.
hospitals, which orphanages?
Listen, Mr. Zogby, you've never met a terrorist that you've ever identified as a terrorist.
That is rude.
All
Rude
right.
for
Let me
you.
just read a statement. Wait.
No.
The Nightline statement, you promised me.
You'll
promised
get
me?
I promise you'll get a chance
Here it is.
later.
He says,
You got it later.
discussing Nightline?
No, come on. You're
right. You give it to me later?
You're abusing your privileges here.
Sorry.
Thank you. Senator Specter, make an opening statement for us, please.
Within a minute and a half, I would say that there is a threat on terrorism in the United States, both international and domestic, that we have crafted legislation which was substantially changed on the floor, amendments that I offered in collaboration with Senator Simon to protect constitutional rights, to try to be sure that those charged who were aliens had a review of the substance of the evidence in a judicial proceeding, that judges would review the classification by the Department of State of a terrorist organization. It's a close question. There is a real threat. I see it from information I get as chairman of the Senate Intelligence Committee. Appended to this bill was legislation which seeks to cut down the time on appeals in federal courts on death penalty cases. Some last as long as 20 years. The average is about 9 years. It sets up a timetable. It seeks to protect constitutional rights by giving defendants adequate counsel. It establishes a priority for a judge in a district court to take a look at that death penalty appeal first. Lengthy time on death row has been held to be a violation of the constitutional rights of the defendant. Certainly without the matter coming to closure, it is very hard on the families. It protects society and I think all parties involved. And I yield back the last second.
Thank you very much, Senator. Who has a question for the Senator? Professor Cole.
I have a question, Senator. You've been a trial attorney, and you clearly know, you still are, and you clearly know the benefits of cross-examination. You use them extremely effectively against Anita Hill in the Clarence Thomas hearings. And the question I have for you,
Judge Bork?
The question I have for you is how, as a defense attorney, defending an immigrant who is accused of associating with a terrorist organization, how would you defend such an individual where the summary that you say will be provided to the alien says you, the alien, are a member of and a supporter of the Popular Front for the Liberation of Palestine? That's the summary that I got when I was defending Fuad Rafidi. The D.C. Circuit held that it was unconstitutional for the government to try to deport Fuad Rafidi based on secret evidence where the only summary was you are a member of the Popular Front for the Liberation of Palestine. How do you defend someone against that charge, short of putting Mr. Rafidi on the stand and have him go through every minute of his life? Don't you need to cross-examine the people who make the accusations? And isn't that exactly the evidence that aliens are not going to get to see in these cases?
I would expect the showing by the FBI and law enforcement to be somewhat more extensive than you have just articulated. And I said on the Senate floor that I was very much concerned about the absence of confrontation, and I made a very careful review of the legal principles. And a deportation proceeding is not a criminal proceeding. It is a civil proceeding, but there are due process requirements.
And the question is, how do you defend somebody when you can't cross-examine the accuser? That's what this bill is going to provide for.
It is obviously much more difficult. And the amendment...
Clarence Thomas would not be a justice.
Let me finish. When the bill was on the floor, Senator Simon and I added an amendment to provide at least the summary. And in our system of jurisprudence, if the consequence is a criminal penalty, then under our Constitution, there is a right of confrontation. There is not a criminal penalty which attaches to deportation, although I'm candid to say that it's not a pleasant consequence. So it is a matter of balancing the interests of society not to have terrorist acts where there is reason to believe the individual is planning a terrorist act, contrasted with the penalty or the consequence, really it's not a penalty, with the consequence which attaches to deportation. This is a very difficult balancing act, and if it were a criminal penalty, then there would be a constitutional right to confrontation.
Mr. Lewis.
Senator, one of your former colleagues, Malcolm Wallop of Wyoming, one of the most conservative senators in his time, has come out against this legislation, saying, among other things, the bill is it's ambiguous and broad in its definition of what constitutes criminal activity. You name it and the FBI can claim it. Similarly, Senator McCarthy, apologies, Mr. Emerson, was ambiguous and broad in his accusations of communist activity. This bill gives federal law enforcement enormous reach into the private lives of citizens. Does it seem odd to you as a moderate Republican running as a candidate for the nomination as a civil libertarian and someone concerned about individual rights that your former conservative colleague should be more sensitive than you to these issues?
Well, first of all, I'm a centrist, not a moderate. Secondly, what Senator Wallop has in mind, I do not know, but I'd be pleased to discuss it with him. With respect to the provisions on confrontation, I have a concern about them. But I think that terrorism is a significant problem. I think the consequence of deportation for an alien who does not have all of the rights that a citizen has, and the summaries which are being provided constitute a fair balance.
Mr. Zogby.
Senator Specter, I appreciate the response you gave to David Cole just now, but I note that in a letter that you wrote recently to the Jewish Forward discussing the legislation, After raising some of those same concerns, you said, we appreciate that in their final form in the Senate, these provisions may not be perfect and that room for improving them may well remain. How would you still improve this legislation to protect civil liberties, as you note in the letter?
Well, I am still troubled by the absence of specification as to what the court reviews when there's been determination of a terrorist organization. I would still like to find some way further, as David Cole suggests, to give a little more information to the person subject to deportation without compromising the source. What you have here that hasn't been mentioned is that law enforcement officials have sources, and the source goes in and finds out certain information. And if he were to testify on the stand, that might well provide a basis for conviction. But that person, this is an answer, but that person cannot be called upon without destroying very, very valuable lines of information. We're dealing with really extraordinary, complicated matters in very, very short sound bites. And for those who want to see an amplification, the record contains very extensive statements which I have made, which is really an effort to balance society's right not to have another Trade Center bombing with rights of a person who's going to be put out of this country, which I'm very concerned about.
I've got to cut off that sound bite.
Okay.
Thank you very much,
Okay.
Senator. Mr. Lewis? It's your opportunity to make an opening statement. It's your opportunity to make an opening statement.
Thank you. A late great American political scientist, Richard Hofstadter, talked about the paranoid strain in American politics, and that has been a factor in our history. It's a wonderful history, but it's had these periodic surges of fear of one group or another. And we are in that state to some extent today. As you know, with the militia movement, the talk of black helicopters swooping down and federal abuse. I think it's extremely dangerous for the United States government, not just individuals in the militia movement or whatever, to join in that kind of paranoia by overdoing the threat. Of course there's a terrorist threat. We can all see that. The question is whether we need to do something that goes as far as this legislation would. And you know, Senator, when you spoke about how you could get around the problem of not being able to cross-examine, and because law enforcement agencies need to keep some things secret, their sources and so on. I lived through, and I believe you lived through, the period when lots of people lost their jobs and were smeared and ruined on the basis of anonymous accusations. And it turned out whenever those accusations, one after the other, were subjected to cross-examination, they dissolved. They were virtually all the result of angry, jealous individuals who accused them of something and hid behind the anonymity.
Okay, if you can hold off, this is a chance for some angry, jealous individuals to cross-examine Mr. Lewis. Ms. Toensing.
Mr. Lewis, wouldn't you then welcome this kind of procedure with this court, because it is comprised of Article 3 judges, and if the summary does not adequately inform the alien and the lawyer of the charges against him, then the procedure cannot continue. Wouldn't you welcome a procedure that is set out, that an Article 3 judge is presiding over it, and you have immediate review of what this summary is about? Because if, on the rare occasion that the summary cannot be used, the judge then decides whether the information against the alien is adequate to support the charges. Do you not trust our Article 3 judge?
Explain briefly what an Article 3 judge is.
It's a constitutional judge, a federal judge that is confirmed by the United States Senate.
And appointed for life.
Yes.
Well, no one respects, indeed, idolizes Article 3 judges any more than I do, Ms. Toensing. So it's hard for me to say this, but experience taught me in the period, the bad period of which I spoke a moment ago to Senator Specter, that judges accept too much under the heading of security. They are afraid to disagree with an FBI or CIA statement because they say, what do I know about it? I'm a judge, I sit here.
But these would be judges who are experienced because they would be put on this special court, just like the FISA court, where conservatives and liberals and Republicans and Democrats alike agreed that the FISA court was good.
Okay, now what's the FISA court?
Sorry, Foreign Intelligence Surveillance Act court, which looks over certain search warrants to acquire foreign intelligence information. And we all came together, conservatives and liberals, and decided this was the way to proceed by having judges who were gaining experience in this area so that they wouldn't be these little innocent lambs looking at foreign intelligence information.
Well, again, I would like to believe it. Perhaps that's somewhat better. But this is not an odd, occasional thing that, like these proceedings that you've just described. There are a lot of deportations. The temptation to use secret information in the hands of on the part of the Immigration and Naturalization Service would be very great, because it's so much easier to win if you don't have to disclose your evidence. I surely don't have to tell you that. You're a lawyer. You're a prominent, successful lawyer. You know how much easier it is to win if the other side doesn't know what you have.
I've never had a case like that.
Mr. Specter.
Well, Mr. Lewis, you put your finger on the crux of the problem. And it is when you have information from from a confidential informant that a given person is planning terrorist activities, and law enforcement wants to maintain that informant, and there's a threat that there may be another trade center bombing. Then we have changed the bill with the amendment that Senator Simon and I put in to require a summary. And you talk about federal judges who have life tenure, and that federal judge is going to take a look at the details of the information provided and make a determination as to whether that is adequate, not to send this person to jail, but to take someone who is an alien, who doesn't have all the rights of a citizen. He could have become a citizen, she could have, and said that in that situation, that person no longer has the right to stay in this country. How would you fine-tune the procedure better to protect both the individual alien and to protect society from another bombing?
In an ideal world, Senator, the procedure would be fine. In an ideal world in which government officials never overreached. But we don't live in that world, as I don't need to tell you. We live in the world we have so far, designed by James Madison and Company when they wrote the Constitution to protect precisely against abuse of power by officials, because nothing is more likely to be abused than the power of officials who think they're doing right. But if there's an easy road, we don't have to produce the evidence, they will follow that road every time.
For a very short follow-up.
Go ahead.
The federal officials may overreach and do overreach, and we have a lot of oversight on that. But how about the terrorist who overreaches?
Oh.
When the terrorist overreaches, you have an Oklahoma City or a twin trade center. So what is the better balance as you try to stop overreaching, the consequence of massive deaths, or you have the judicial review, which has been the hallmark of our decency in society?
Senator, if it were a question of the safety or the rights of one individual against Oklahoma City, of course, it would be an easy question. But there's nothing in this bill that would have affected Oklahoma City at all, whatever, nothing to do with it.
How about the twin trade centers?
The trade centers, there was, in fact, an informant to whom, unfortunately, our government didn't listen. And the other planned bombings in New York, even worse, as Mr. Emerson candidly stated, we knew all about it. We were able to stop it under existing law. So I just don't see the urgency to bend the rules.
Thank you very much, Mr. Lewis. Mr. Buckley, this is your best chance to interrogate William F. Buckley. Who's going to start? Ira Glasser.
Bill, under current law, if the FBI has a reasonable basis for believing that a crime is being committed or about to be committed.
What's reasonable?
Reasonable is a term of art in the law that...
Well, was it reasonable that Alger Hiss was a Soviet spy? It was
reasonable, but you want to ask me to answer the question, or you want to play games?
No, I'll anticipate.
I mean, reasonable is a word that nobody alive can define, like probable cause. But lawyers and judges know what it means. It means a certain quantum of real evidence that the person being investigated is involved in a crime. There are facts to indicate that, and there are facts to indicate that they're planning a crime.
What's your question?
If the FBI wants to investigate, infiltrate a group, wiretap an individual now, If they have facts to believe reasonably that they're involved in a crime, they can do it. Why would you want to give the FBI the power to do that without any evidence that anyone is involved in a crime?
I'm not. What we're talking about is the threshold. That is the critical word. Different thresholds are applied in different situations. If you want to visit the nuclear retaliation nuclear plant in Omaha and fiddle around, the chances of getting in are less than they are of getting in, say, to the White House on a simply tour. Now, the question of threshold is the operative question here. To what extent should one be satisfied that there is a probable cause? And as we know, in 1975, after the church hearings, the level of threshold was lifted in the direction of inhospitality to informant information, and again lifted after Abscam, when 6 congressmen were detected taking money and filmed in the process. They became very inhospitable to the idea of operating in a way which we maintain is required to anticipate the actions of terrorists.
Well, but let me just follow up, if I
Briefly.
may. It was lowered, which you did not say, by Attorney General William French Smith, and the current ones say that the FBI can initiate an investigation, including wiretap and infiltration, in a domestic security terrorism investigation when the facts or circumstances reasonably indicate that 2 or more persons are engaged in activities that involve
You're
force.
the same thing. You're saying
What
the same
less
thing.
would you like?
And I'm saying that what is reasonable is differently interpreted.
But the bill,
I'd have thought it was
all.
reasonable to look in Rahman when we had an
You're
informed.
misconstruing what the
FBI
bill
didn't
says.
think it was
Okay,
reasonable.
we're going to move on. Mr. Lewis.
Just a bit to follow that, really, but with a concrete example. After the FBI rules were relaxed by Attorney General Smith, the government launched, or the FBI launched, a very pervasive and intrusive investigation of thousands of Americans whose political beliefs differed from the official government line of the time on what we should be doing in El Salvador and Nicaragua. They were hounded, their belongings were seized, and so on. That seemed to me quite a dangerous thing, and it was done under existing law, and you want to make the law even more relaxed, removing the element of necessity of some kind of criminal act before you investigate.
Well, I want to do the right thing. If the CISPES business was overdone, there is a position that says yes, it was. There is a position that says no, it was not. That particular committee, in solidarity with the people of El Salvador, was in fact the operational unit of a subversive front determined to wage civil war in El Salvador, which we opposed. Now, if you can say, well, here's a guy who should not have been deported but was deported, I'm perfectly prepared to concede that those things happen. But the level of sensitivity is crucial to our argument. Do the terrorists represent a distinctive threat? Answer, they do. And therefore, do we need distinctive weapons to anticipate their action? Answer, yes, we do.
Mr. Cole.
One of the distinctive weapons that this bill would introduce for the first time is making it a crime for U.S. citizens to support wholly lawful activities of any group that the president designates as terrorist in what is essentially an unreviewable designation. Do you think that's a fair balance of First Amendment rights of freedom?
I think that you unfairly condense those provisions. In the first place, there has to be mens rea. You got to prove that the person who did it had some, am I correct?
There's review.
And there is judicial review.
But the crime, Mr. Buckley, the crime is if I send money, if I send medical supplies to a hospital run by Hamas, after the president designates Hamas to be a terrorist organization, I can go to jail for 10 years for sending medical supplies to a hospital without any proof that there was any kind of support of terrorist.
To the extent that you are engaged in helping terrorist or para-terrorist activities, it should be a crime. There might be an argument whether you should spend 30 days or 3 years in jail, but you ought not to be entirely at liberty to help Hamas at any level.
But you're not. You're not.
I got to cut you off. Thank you very much, Mr. Buckley. Mr. Glasser. captain of the opposing team. Who wants to take a crack? Steve Emerson.
Mr. Glasser, in the World Trade Center investigation, as Mr. Lewis pointed out, there was an informant who was let go for reasons connected to personality differences at the FBI. However, there were also applications for wiretaps on the Sheikh's home in New Jersey and in Brooklyn, which were denied repeatedly during the period that he was allegedly plotting to blow up the World Trade Center and other acts of violence. Under the new bill that is proposed, the standard would have been lowered by which federal and law enforcement agents could have gotten permission for a wiretap and probably stopped that bombing. Do you agree with that assessment? And if so,
No.
Okay.
The wiretapping, there's been in the last 10 years maybe 9,000 or 10,000 applications for wiretaps. 7 of them have been denied. Wiretapping has a very low standard now, but it does require the authority who wants to wiretap to show some reason why there is a reason to believe that a crime is being committed or planned that the wiretapping would be useful to uncover. If they can't even show that, they don't get the warrant. That's only happened 7 times out of 9,000 or 10,000 applications. Now, what this bill would do, and I might add that every time a tap is put into place, the government's own reports show that 1,800 innocent conversations are overheard for every one that's incriminating. So you're dealing here with a vacuum cleaner of a warrant. And what happens is that you want to create a bill here which would allow the government to get a warrant to wiretap without any evidence of criminal activity at all.
no, I don't think that's the case.
What are you going to use if you don't use criminal
But I
activity?
think
You're going to use political associations?
Doesn't the
You're
bill
gonna use Arab
recognize?
names? What are you going to use?
Doesn't the bill recognize that the changing nature of terrorism requires that a certain threshold be changed, and that in the case of the World Trade Center bombing, they finally received the wiretap application process only 10 days before, and they could have had it 4 months before.
If the threshold does not include evidence of a crime, what should it be? Should it be political belief? Should everybody who supports, joins the NRA be wiretapped? Should everybody who writes a letter in support of the Second Amendment be wiretapped? Should everybody who opposes abortion be wiretapped because some lunatic blew up a clinic?
Mr. Glasser,
what are you talking about?
When it's my turn, I'd like to answer that question.
It is your turn.
No, but it's my turn to ask you a question, but I'd like to play with that answer when I get to go up to the podium. I want to change the subject back to a question you were asking Mr. Buckley, and that is, I think you were referring to a statute which prohibits providing assistance to overseas terrorism groups, material assistance to overseas terrorist groups. And in that statute, there is a provision that says, guess what? You can't investigate unless you know there's criminal activity. That's a problem for any one of us who's been experienced in law enforcement, because until you really investigate, you don't know that there's been criminal activity. You only have some kind of a suspicion that there could be. You need an investigation. How, pray tell? Because I think the ACLU is opposing the retraction of the deletion of this provision. How do you possibly investigate before you have criminal activity?
Well, that's a real interesting question. The folks who wrote the Fourth Amendment thought about that one a long time in the 18th century. And of course, the conclusion is, if you don't want to wait till the last minute, if you don't have if you want to investigate everybody who, without any evidence of criminal activity, because who knows, you may be committing a crime, what are you proposing to do? I mean, if you're not going to use some evidence of criminal activity, what are you going to use as the trigger to authorize a wiretap? What?
What about 2 anonymous phone calls?
2 anonymous phone calls?
That says there's going to be a bomb.
That says there's going to be
going off next week in the World Trade Center, and this person living at this
address.
I'll tell you
what, I'll arrange for 2 anonymous phone calls to say that about you, and you tell me how you like it.
And they're both consistent.
Now, that's not evidence, and you know it.
What that
would do is it would open up all of the horrors that we've experienced throughout our history when you give the government power to do something without evidence of a crime. What they do is they end up using something else as a proxy, and the something else turns out to be race or national origin or political beliefs.
Senator Specter.
A big part of this legislation cuts down on federal appeals. There is a lot of authority for the proposition that if the death penalty is swift and certain, that it is a deterrent. People want the death penalty on the victims of families to bring the issue to closure. Some courts have said that if you hold somebody on death row for longer than 6 years, and the average time is now 9, and in some cases as long as 20, that if you hold someone on death row for 6 years, it's cruel and unusual punishment to the individual. Do you think that's true?
Well, I do think it's true that to hold someone on death row for a long time is cruel and unusual punishment, and I do think that swift justice is an element of justice. But the answer for the lack of swiftness of justice is not to eliminate justice entirely by eliminating the right to appeal. Moreover, the notion that the death penalty, which has never been shown to be a deterrent for ordinary homicides, would be a deterrent for people who are messianic about blowing up people that they don't like, is nuts. There is no evidence to suggest that a deterrent of the death penalty would possibly affect the kind of terrorists that we're dealing with. I do not understand why that's an issue.
This provision applies to broader cases than terrorism, and it does not eliminate appeals. It simply establishes a procedure to expedite them.
Thank you both. Thank you, Mr. Glasser. Now, the opposition team is under no obligation to ask Victoria Toensing the question she tried to plant, but if anyone wishes to, they may.
But I get to do my minute and a half first.
Oh, of course, I apologize. Go right ahead. And you can answer that question in your minute and a half if you wish.
No, I'll wait. A nation's first priority is to protect the security of its citizens. And we have always understood this concept in the context of war. Indeed, over the centuries, we have crafted rules that uniquely apply to war. However, today, we don't do wars anymore. At least we say we do not. We have skirmishes, we have conflicts, we have military advisors. And so thus, the rules that were created for war no longer come into play. Yet terrorism is a form of war. There is certainly violence directed not at the army in the battlefield, but at the innocent civilians waiting in line to cash a Social Security check in the federal building in Oklahoma. Just as the rules of engagement for war need to address the issues of what really is out there on the battlefield and with the enemy, so too must our legal system address what is the concerns of the terrorist threat. We made one crucial change in the 1980s, and that is we established extraterritorial jurisdiction over terrorist attacks occurring outside of the United States directed at Americans. Thank you, Senator Specter. But there are other legal gaps still there. We can't, for example, deport aliens who are in the United States who are involved in terrorist activities. Well, we certainly can't do it within any reasonable time period. Could some of the legislation be changed, be modified to be improved? Of course. Could some of the provisions be deleted? Absolutely. But does that make it different from any other legislation? The bottom line is this. We have, I'm just getting ready to finish, we have legal gaps in our legislation and this in our legal system to fight the war of the 21st century, which is terrorism. This legislation will help fill some of those gaps.
Thank you, Mr. Cole.
Ms. Toensing, you take credit for drafting the secret evidence provision during a previous administration, which has now been passed by Congress.
10 years ago. Almost 10 years ago.
Yeah.
And you know what I said at the time? It's going to take some people to be killed before we're ever going to get this legislation passed.
That's right, and it's in response to hysteria and panic and concern about the Oklahoma City bombing that it has, in fact, been passed by the Senate. But the question I have is, every time the INS has tried to use secret evidence in the past, it has been struck down as unconstitutional. It was struck down in 1953 by the United States Supreme Court. It was struck down in 1988 by the D.C. Circuit, and it was struck down just last year by a federal judge in Los Angeles. Each time, the courts held that due process, at a minimum, requires that an alien be confronted with the evidence against him because there is no realistic way to defend
Yeah, but David,
oneself.
that is
In those
statutory.
cases,
And if
let me finish my. In those cases, summaries were provided. A summary of the information was provided. Now, the argument I've heard is that you can't compromise sources. But isn't it a fact that the government has to make the choice of compromising sources in every criminal prosecution, no matter how horrendous the crime? They have to choose whether to put the source on the stand where he or she can be cross-examined and the truth can be told, or not proceed with the prosecution. The same has been true in immigration
That's your
proceedings.
question.
All right,
Now,
I
here's
must
your answer.
distinguish, of course, between a criminal case where our national security is not involved
Well, how
and
about the
national
World Trade
security.
Center?
Let me finish.
How about the World Trade Center? National security at stake. You can't use secret evidence in the World Trade Center
That's
bombing
right.
case.
And you know, you just brought up the best distinction because we're talking there about a criminal case and not about deportation. When we are talking about deportation, and I'm sure you'll concede this, that the Supreme Court has said if Congress ever gets it right and makes laws clear, excuse me, Senator Specter, and writes clear laws, we will uphold them because we give a lot of deference to the legislature and the executive in the areas of national security and deportation of aliens. So the only reason that these laws have been overturned by courts is that Congress didn't write them clearly enough, and now they're attempting to
it's
do
not a
so.
question of
It's not a
clarity.
constitutional issue, it is a policy
No, it's
issue.
not a question of clarity. In all of those cases, the bottom line principle was an alien is deprived of his due process rights that he is entitled to as a person within the United States. A person within the United States by using
David, if
secret
that's the case, why has a summary been upheld in a bond denial hearing? Certainly if a court is upholding a summary of information to deny somebody their liberty interest in a criminal case, it can clearly be upheld
Okay, that's a
in a
rhetorical
deportation.
question. Mr. Lewis.
It was.
This may violate the...
No, I'm ruling it a rhetorical question. That's unappealable.
This may violate the combative rules of a debate, but you intrigued me by something you said in your opening statement, which was toward the close you said, well, there are some parts of this legislation that I might like to change or that I could improve, and I'd like to know what they are.
Yes, because does that make that legislation different from any other piece of legislation? I'm sure there's not one. I would be delighted.
I'm just interested in your view.
I am not for the fundraising. For the fundraising, is the microphone loud enough? And probably not for the same reason you're against it, but who cares about motive around here? It's the bottom line that counts. I am not for it because I think all the safeguards that need to be put into it, and they're all thrown in there now like a big, mix master, make it unworkable. I think it's ridiculous that if you're going to name organizations to which you cannot donate funds and whose bank accounts may be taken over, that you give them notice of 7 days or 30 days, I forget what it is in the final legislation, Senator Specter, but if I'm a terrorist group and I know that my bank account is now on the president's list, in that 7 days, I think I'm going to empty the bank account. So I don't think it's workable. And because of my concerns about the First Amendment, I don't think all the safeguards that you have to put in there make it workable on the fundraising. But that's the only one I'm against.
Mr. Glasser, very briefly.
When the director of the FBI testifies before the House committee that he thinks the FBI's investigative authority is adequate under current law and the current guidelines, on what basis do you disagree?
I do not disagree. I agree.
So why are we changing the law?
Well, I don't think we are changing the law, but let me tell you, they are not changing the law. The FBI guidelines are not being changed. What the problem is, and I bet you if you ask Louis Freeh this follow-up question, is although the guidelines are worded broadly enough, the Justice Department, from which I was a member and I'm personally aware of this situation, the Justice Department and the FBI are so concerned that 3 years later, either a conservative group or a liberal group is going to be hauling them up, and they don't know which one, for any kind of investigation of any particular group, that they are very careful about using the full breadth of those guidelines. And so that's the problem the FBI is having with the guidelines.
Thank you very much, Ms. Toensing. Professor Cole, this is your opportunity rather late in the game to make an opening statement.
Right. Well, I think it's interesting that the title of this debate is whether the anti-terror bill is good for Americans. Because we are, after all, a country of immigrants. And the people who are really harmed by this bill, most harmed by this bill, are immigrants. An immigrant under this bill can be deported for sending medical supplies to a West Bank hospital. An American has a constitutional right to send medical supplies to a West Bank hospital. An immigrant can be deported for that. An immigrant can be deported on the basis of secret evidence, as we've gone over. An American has the right to see the evidence against him. Immigrants do not. Immigrants are denied judicial review if they are charged with being deported for criminal activity. Americans get judicial review. The Supreme Court, however, has said repeatedly that the Bill of Rights protects all people in the United States. It does not distinguish between citizens and immigrants except with respect to voting. This bill denies to immigrants some of the most basic freedoms that we insist upon for ourselves. But it also denies them to ourselves. Americans, for the first time, will be subject to 10-year prison sentences for supporting the lawful activities of a group that engages in unlawful activities and is designated as terrorist. And that designation by the Secretary of State will be unreviewable by the individual who is facing a 10-year prison sentence for doing nothing more than what he is constitutionally entitled to under the First Amendment.
Thank you. Mr. Buckley.
Professor Cole, my summary of the bill advises me in respect of the point you make that quotes, the bill does not include an administration provision to permit donations to these groups, i.e. these alleged terrorist groups, if donors could prove the money would go solely for charitable or educational purposes. As I understand it, that means that John Jones sending money to this hospital, even though that hospital was an arm of Hamas, would not in fact run the dangers that you are so apprehensive about.
No, in fact, he would, because the bill does not include any exception. As what you said was the bill does not include an exception which the administration originally suggested that would allow a citizen to come forward and say, I'm supporting only the charitable activities. That provision was taken out, and it is a crime to support the charitable activities, even if you can prove absolutely that the only thing that you did was send medical supplies to a hospital. That is a crime. You are in jail for 10 years for doing that.
How in fact would you prove that the $100 you spent went to bandages rather than to explosives?
Well, you could send bandages. You could send the money to the hospital and say this should be used for bandages. What the Supreme Court has said for years is that in order to avoid imposing guilt by association, where an organization engages in both lawful and unlawful activities, the government bears the burden under the First Amendment to prove that the individual specifically intended to further the unlawful ends of the group.
Don't we all acknowledge that we are here distinguishing between aliens and citizens?
No, because what we're talking about, what you and I are talking about right now, is a provision that puts 10-year prison sentences on citizens for supporting lawful charitable activities of groups designated as terrorists.
Yep.
In fact, the provision, as the proverbial line in the Justice Department is, one can always indict a ham sandwich. And the fact is that the laws can be abused by anybody. Now, under the counterterrorism legislation and the different permutations that have been submitted in the Congress, if an organization like Hamas is designated a terrorist group, and a person does give money to an apparatus or a sub-wing of Hamas, he can be prosecuted. What is wrong with that?
Well, what's wrong with that is, I think the Clinton administration said what was wrong with that best a year ago, when Congress was proposing to make membership in Hamas an excludable offense. They came in and they testified, yes, Hamas engages in terrorism. There's no denying that. But there's also no denying that Hamas is one of the biggest providers of social services and charities in the West Bank. Many people in the United States feel an obligation to support people in the West Bank through charitable services, hospitals, et cetera. And for that reason, the administration said, you can't assume that because somebody's a member of Hamas, they are a terrorist as opposed to a doctor. For the same reason.
Isn't there a licensing provision to prove that they can show? Isn't there an appeals process? Isn't there a review process? Doesn't that call for?
For the U.S. citizen charged with sending money to a hospital, there is no, that person cannot challenge the designation of the group as a terrorist at all. That person cannot attempt to prove that he was supporting only charitable activities. He could attempt to prove it, but it would be irrelevant. He is subject to a 10-year penalty for supporting charitable activities of any organization that is designated. The only review...
And the government has to prove that case.
You mentioned review. Well, all they have to prove is that he sent money to a hospital. Now,
that was designated as a terrorist organization.
To put someone in jail for 10 years. Now, as to terrorist organization, it does not have to prove that the organization is a terrorist organization when it prosecutes a citizen. The bill does allow, and Ms. Toensing referred to this, the bill does allow for Hamas. If Hamas is designated terrorist, it can come in and try to challenge that designation in court. However, in that proceeding, the government can rely on secret evidence that Hamas doesn't see. Second, the standard that the court has to apply is, does this group's activities threaten the foreign policy, national security, or economy of the United States? The Secretary of State will have made a finding that that is the case. No court is going to second-guess the Secretary of State on his finding that any group's activities threaten the foreign policy of the United States.
Specter.
So it's an
Senator
unreviewable
Specter.
designation.
Well, Professor Cole, at the outset, I would challenge your assertion that no court's going to disagree with the Secretary of State. They do it all the time. But let me come to
Not on questions of foreign policy.
Let me come to my question. I have a very great regard for immigrants, and I don't like all the picking that's going on about immigrants in this country today. But immigrants have a right to be protected too. There's very little time left, but the core question that I come to is, how do you establish the balance? And maybe you have a better idea than we had in the Congress, and it's worth exploring.
Okay.
Where you have a confidential informant who has information that a person is planning to engage in terrorist activities, and you're fearful of another trade center bombing, what better way can you find than having the evidence summarized before a judge who goes through it to be sure that before he's subjected to deportation, there are adequate grounds to do so?
Answer that in about 5 seconds.
The better idea that I have, I can't really take credit for, because it's the better idea that the framers of the Constitution had, and that is due process. And the most basic principle of due process has always been that you have to be able to confront the evidence against one. We have lived in the United States for over 200 years confronting the most serious criminals, the most serious threats of immigrants with the evidence against them. And every time we've sought to use secret evidence, it's been held violative of the Due Process Clause.
Thank you very much. Thank you very much. Thank you very much. Mr. Buckley and Mr. Glasser. Mr. Buckley, you can begin by questioning Mr. Glasser.
I question him?
Yeah, if you don't mind. Or even if you do mind.
Mr. Glasser, you said twice, you do tend to repeat yourself, that the FBI has pronounced itself as satisfied with the existing resources, correct?
That what?
That the FBI has pronounced itself as satisfied with existing resources.
That's what the director said at the House Judiciary Committee hearing, yes.
Well, why did...
Not sufficient resources, sufficient investigative authority is what I said. Since I said it twice, I guess I have to say it a third time. See, that's why I repeat myself.
Well, why did the director say, quotes, for 2 decades the FBI has been at an extreme disadvantage with regard to domestic groups which advocate violence. We have no intelligence or background information on them until their violent talk becomes deadly action.
Well, I don't know why he said that or when he said it, but I do know that advocacy in this country, no matter how militant, is not a crime. The Supreme Court has said so. It should not be a crime. If it were a crime, many people would be. So if he doesn't like that, too bad about him. He ought to read the Constitution. The issue is that we're trying to figure out whether we need new legislation to get on top of terrorist crimes.
Yeah,
the director said he didn't need any.
Incidentally, all this business about Madison got it right in the first place. You people are in favor of evolving the Constitution every other day. Nobody is happier than you are when the Supreme Court comes through with an entirely revised Constitution. So don't
depends on how they
revise. Don't tell me all of a sudden you become nostalgic for the Constitution.
Only for their principles,
okay.
Bill. Only
now,
for their
but
principles.
we're trying to establish whether or not there is, again, a distinctive threat. Now, FBI informants were reduced from 1,100 to 50 during the 80s, and the question arises, does that make sense? Given the metabolism of current terrorist
I have
activity.
testified before Congress, and I am happy to say so again. There are no civil liberties objections to increasing the number of agents if more resources are needed. The question before us is not that. The question before us is whether broader investigative authority that does not depend on evidence of a crime is what's needed.
Okay,
That's the question.
Let's take those 2 anonymous phone calls over which you had great merriment and say, well, you'll try phoning somebody and making the same call. Now, why don't we begin by agreeing that 999 anonymous phone calls are entirely harmless, but then go on to agree that there's the incremental phone call that isn't harmless. And then we ask the question, what ought to be done. We know in the case of the President of the United States, every anonymous threat is tracked down. We don't have the resources to do that, but the principle is embodied, again, in a threshold. The President of the United States, as a critical figure in the nation, gets enhanced security attention over against that of a senator. Now, if we talk about a situation in which there is some evidence in that 1,000 phone call or some intimation that a plot is designed, as was done in 1981, to kill a visiting prime minister and a lot of top executives, does it make sense to pursue that and establish whether or not there might be a terrorist gesture?
The answer is it does, and the FBI has authority to do so now. They can make what is called the preliminary inquiry, and they can follow up the lead, and they can investigate the validity and accuracy of the anonymous phone call and the facts that it provided. Let me finish. And then, if they find anything as a result of that preliminary inquiry that's credible, then they can go and apply for a warrant. But if what you're saying is merely on the basis
find the dynamite
don't be playful about this. There is real criminal evidence. The Fourth Amendment talks about a reasonable basis for a search warrant. A reasonable basis means you have to have articulable facts.
We're not talking about criminal prosecution on us.
Supposing I call, yes, we are. Yes, we are.
Well, at the margin we are, but not right now.
No, not at the margins, at the center.
I'm at the center. Go on defensive now.
Let's continue this dialogue, which makes the most sense. In the CISPIS investigation, which I believe you mischaracterized before, we had a group of people who at worst might be called harmless and ineffectual, who were infiltrated and investigated for 27 months without any warrants, under current law, because they were said by their own admission to be supporting the opposition in El Salvador. The government of El Salvador was a terrorist government. Some of the opposition was terrorist. They themselves were doing nothing.
And your question is?
My question is, since they never found any evidence of a crime, since the government continued to infiltrate them for 27 months merely on the basis of their political position in El Salvador, the FBI has admitted that.
No.
Yes.
No. They were investigating them on the grounds that there was probable reason to suppose they would act.
What's your basis for saying
as intelligence.
Intelligence?
Yeah.
Are you in the CIA without my knowing it?
Yeah. As they acted there.
No. Bill, you're making this up, Bill.
Nothing is more satisfying than to pursue somebody and find out that he hasn't done anything.
Bill, it didn't take him 27 months of living in your house to find out you weren't a terrorist. The fact of the matter is, here's what happened. Let me tell you. What happened is that they said in their own fundraising literature that they supported the opposition in El Salvador. The administration of this country thought that the parts of the opposition were terrorists. They therefore, designating the opposition as terrorist, took that fundraising letter by this organization and said, they must be supporting terrorists, we better take a look. Okay, they took a look. Then they infiltrated them, they investigated them, and they kept an informer in their business, in their homes, in their offices, for 27 months. They never during this time found any link to support the supposition. Why should they be allowed to do it?
Is it your point that curiosity should have term limits? Only 27 months of curiosity?
My position is that people in this country oughtn't to be investigated and infiltrated and wiretapped because of their political opinions. That's what happened in that case. This bill would legalize that.
Lenin's political opinions were that you and I should cease to exercise freedoms. Now, we have to make certain deductions on
what follows from that.
One of his political opinions was that Trotsky should be dead. And before you know it, Trotsky is dead.
And so somebody who says kill the umpire, Bill, should be wiretapped?
No, I think that anybody who was a Stalin agent in Mexico should have been surveyed.
Jesse Helms said that if the president comes to North Carolina, Jesse Helms said that if the president comes to North Carolina, he better wear a flak jacket. Should he have been wiretapped?
Oh, that's just her block
Oh,
humor.
that's
Everybody
no, that
does
isn't her block. That's Jesse. He said it.
But that's his version of her block humor. You do it in the Washington
And so
Post
what
every
happens
day.
is, and who is the genius who's supposed to decide which of those things are humorous and which of them are real that
Well,
justify somebody infiltrating?
You can ask me, and I'll tell you.
I know. That's what I'm worried about. That's what the
I'm worried
Constitution was
about-
designed to protect was against
you don't
you.
understand the kind of problems that are faced by people who are trying to track down possible loyalty or security risk. It takes tons and tons
Loyalty?
and tons of patience.
Loyalty?
Yeah, loyalty to the first to the.
How about loyalty to the Constitution?
That's what I'm talking about. I said loyalty to the Constitution.
And should people be
so
wiretapped who want to
if
repeal
one
it?
is disloyal to the Constitution, one proceeds, therefore, to feel at liberty to press instincts of a political character, which are very well known. The Narodniki had political principles, and they were simply to kill the nearest relative of the Tsar.
But the question is whether or not you infiltrate and wiretap people based on what they say or what they do and where you draw the line. A lot of look at the abortion situation. It's a hot subject. It is the leading example of terrorism in this country in the last 10 years. Are you supposed to tell me that everybody in the Right to Life movement is supposed to be infiltrated and wiretapped because some of them kill people?
Okay, all right. You have 50
There are those
seconds to
magazines
answer
that advertise spies and explosives and whatever, and I think it's entirely reasonable for the FBI to survey who subscribes to those.
So
on the grounds that
Operation Rescue membership is cause for wiretapping that.
if there is
Say yes.
if there is some kind of a threat
Say yes.
to explosion. Yeah.
Oh, yes, thank you both. Thank you both. Mr. Emerson. Mr. Emerson. Mr. Zogby, you must have a question for Mr. Emerson, I suspect.
Right. Steve, when you make the kind of allegations that you do about Arabs and Muslims, although you attempt to throw in the disclaimer at times that you don't mean all Muslims, you just mean the radicals or the fundamentalists, when you do that, oftentimes it's about as believable as the boss who says he doesn't discriminate amongst his employees, but boy, she's a real hot babe. I wonder if you ever feel any sense of the effect that it has on the Arab and Muslim community, what you say and what you do. In the aftermath of Oklahoma City, for example, the repeated references to the film Jihad in America, and Oklahoma City being the, as you called it, the #1 hotbed of radicalism outside the Middle East, that tiny community of Muslims was subjected to an awful lot of hate, an awful lot of fear, and an awful lot of trauma. Do you feel any responsibility for that? And don't you feel that there's a danger in loose words having impact on people's lives?
I feel that you've just demonstrated the true definition of McCarthyism by making all those statements, Jim. The fact is, Jim, this is, you let me finish. I'm the one responding here. Jim,
today. You're the only one to use it,
Jim,
Steve.
please let me respond. Number one, the issue of Islam and fundamentalism is an issue you and I can debate for many years. However, the issue before us today is the issue of the terrorist threat in the United States. And that includes everybody from the Jewish Defense League to political militant Islamic groups to the Irish to everybody else. And that's the issue we're debating. You're trying to put a smokescreen right now by focusing on statements that you are either attributing to me or either they're being made up. The fact is, Mr. Zogby, that the World Trade Center did happen. That the legislation that was designed by the president and is now being debated was designed in response to that bombing. That political militant Islam is a fringe movement of the larger mainstream Muslim community that does not support violence. And just accept all that. Why do you feel compelled to defend the terrorists? Let me just say one thing right now, because I borrowed 30 seconds before. You said on Nightline, following on 6/25/1993, and I think this will be the further information that everyone wanted before, that there were moral grievances to those that carried out the World Trade Center bombing. We need to understand them. I don't believe in the
Read
issue.
the quote directly.
Please.
Stop artfully playing
Please,
with my words.
look,
Read the
I will
quote
circulate
exactly.
this
All
to
right,
anybody who
hold
wants it
on.
afterwards. The bottom line, however, is
No, what did
Islam
I say?
has nothing
Steve,
to do
what
with this
did I
debate.
say? Steve, what did I say? Read
Okay,
the
the
quote
fact is
exactly.
we need to understand it. We need a foreign policy that understands how to balance our interests, the moral grievances that is longstanding, the moral grievances that were would like to eradicate a big piece of
No,
property
Steve, read
in Lower
the quote
Manhattan.
I uttered.
The fact,
you said that
this
I
is
said
it.
that the people who bombed the building had moral grievances. Read what I said and stop playing
You are
with
talking about the rationale
Is that
behind the bombing. This
no,
is
Steve,
it.
that's not a transcript.
Mr.
That's
Zogby,
from
right, hold
the
on.
issue is not about
on
this.
my quotes.
Mr. Zogby,
Read what I
Mr.
said,
Zogby,
Steve.
please.
I'll tell you
We'll
what.
continue later on about that. The issue is not about
you insisted
Islam.
on reading it. I want you to read my
The
words.
issue is not about Islam. The issue is about terrorism. It's about Jewish terrorists. It's about Islamic terrorists,
All right.
Irish terrorists.
Good.
And that's the issue we're facing today.
Okay.
Don't distract from that debate.
All right, Mr. Cole.
You've characterized this bill as a response to the World Trade Center bombing, but it is in fact the case that current law already makes illegal the World Trade Center bombing, makes it prosecutable, and people can be prosecuted even for conspiring to blow up the World Trade Center. You've made a name for yourself by making a documentary which alleges that various people in the United States are raising money for terrorist activities, That's illegal under current law. Why then are you supporting this law, which does not criminalize those activities which are already criminal, but instead criminalizes people who send money to a hospital run by Hamas?
Well, I appreciate the question. The fact is that what the documentary did and what the administration, in terms of their national security apparatus, has found is that the changing nature of terrorism has evolved in the last several years so that no longer does one just give to a group that explicitly states, I am a terrorist. All of these groups now hide behind the politically correct terminology of being civil rights groups or charities. And the bottom line is we need a way to stop the money from being fungible, from being directly diverted or indirectly diverted to terrorist groups. And those groups that subscribe to Hamas ideology should be barred in terms of receiving funds.
Thank you, Mr. Emerson. Mr. Zogby. Mr. Emerson, or who has a question for Mr. Zogby? Go ahead, Mr. Emerson.
Mr. Zogby.
Read the quote, Steve. Go on.
Mr. Zogby,
Yes, Steve.
in fact, I'd like you to read the quote.
Okay.
Do you have it?
No, Steve,
Okay.
I don't.
All right. Mr. Zogby.
Why don't you pass it up?
Okay. Yeah, well, let's pass it around.
It's not the quote. It's a transcript from APEC, and it's a
It's not a-
summary in an
It's a transcript
intelligence
from
report that they
Nightline.
issue.
I didn't realize
It's
that
not
Nightline equals APEC.
But anyway, I know what
Please,
it looks like. Go on,
let's
read it.
discuss the issue
Ask the
here.
question.
Do you think that in the wake of Oklahoma, when you said that if we had a counterterrorism bill, we would have had mass deportations, we would have had roundups, do you really think that that would have occurred? And don't you think that lends to this hysterical, incendiary reaction in a community that already feels under a certain amount of anxiety?
Steve, I went to the FBI in the early 80s, during the time of the Israeli invasion of Lebanon. I brought with me, met with the director, and brought with me 104 affidavits by Arab Americans, mostly from Southern California, reporting on FBI visits to their homes, sometimes at 3 in the morning, sometimes to their neighbors, sometimes to their employers. In every instance, they were harassing visits in an effort to kind of get information from the community. I also brought with me 12 affidavits from Arab Americans complaining of threats of violence or actual acts of violence committed against them. I asked the FBI then, as I asked them on numerous other occasions, why do they spend so much of their resources harassing my community and so little defending their rights? Incidentally, 4 of those 12 affidavits came from Alex Oda, who was later murdered when a JDL bomb, or allegedly JDL bomb, went off in front of his office. I asked the FBI on a number of occasions why they persist at these waves of interrogations of Arab Americans. In fact, the LA 8 case taking place in Los Angeles still till this day is a case designed to test whether or not you can deport large numbers of immigrants based on their political ideology.
Mr. Zogby,
I am concerned.
Mr. Zogby, don't we have
I am concerned about the political rights of Arab Americans, and I've seen threats of deportation
mass
before.
deportations.
Mr. Emerson, you've had your chance.
Okay.
Ms. Toensing.
Mr. Zogby, don't we have a problem, though, if we cannot pass any new terrorism or anti-terrorism legislation because you are concerned about one ethnic community? I happen to be Irish, and of course there are a lot of Irish terrorists. We talk about Irish terrorists all the time. I don't take personal offense. So I am asking, don't we have to step back and say we're all Americans and we should be concerned about the citizens here
Actually,
in the United States?
we are, and Arab Americans support much of what is proposed in the legislation. We support the tagging of explosives, and we support increased funds for federal law enforcement, and we support many of the provisions. There are a couple that we don't support. And what we don't support is the rhetoric that has surrounded the legislation. When, for example, two members of Congress, in an effort to build support for the legislation, circulated Steve Emerson's film, Jihad in America, saying, watch this and you'll know why there's a threat facing America. We do not want to see this legislation passed over the hysteria about Arabs and Muslims and the threat that they present to America. If the debate can take place in a cool, calm atmosphere, if it can take place without...
So we don't have to change the provisions, only the debate.
Actually, that would be very helpful. And I think that much of what's been done already to amend the legislation has been helpful. What concerns me is that it is posed that we need the legislation because of the threat of Arabs and Muslims and the threat that they pose to America. That's actually why I'm here. Otherwise, I wouldn't be here and Steve wouldn't be here.
Wait.
We'd be having a discussion among lawyers. He and I are both the non-lawyers here, and we'd be talking about it without any reference to Abu Ghula or whatever, and there wouldn't be any concern.
Mr. Zogby, who has said that we need this legislation only because of, quote, Muslims and Arabs? Who is? Give me one person who has said that.
Pretty much you.
Pretty much?
Senator Specter?
Give me the quote. Give me the quote, Mr. Zogby.
I'll tell you
You
what.
sound like the person behind the podium used to say, I have a piece of paper here. Tell me the quote.
Steve, your references to McCarthy are many and repeated. But anyway, when we debated each other on McLaughlin's one-on-one, you were arguing very vigorously the need to have the legislation at that point and making reference to the threat about Islamic radicalism
I said
in
militant
America.
Islamic terrorist groups here.
Right.
Why don't you recognize that there is a problem with them as well as with other groups?
There is.
Recognize
There
it.
is. I do.
Say it.
I do. But I don't happen to ride that
never
hobby
heard you
horse
say it
exclusively
till
like
today.
you do, Steve.
Thank you. Thank you both, I think.
We've added some color to life.
No, thank you. I appreciate it. Mr. Specter, it's your chance. And Mr. Lewis. And it's Mr. Specter's chance to ask some questions of Anthony Lewis.
The format says that I have 5 minutes to ask Mr. Lewis questions. What I would prefer to do would be to have a discussion where we ended up on our last exchange.
That's good, because you really only have 4 minutes.
When you strike a balance, and you had made a comment in my questioning about the Trade Center bombing, obviously it's a major problem. Many people are killed. And you have a need to protect the source. Somebody has access to a group of terrorists. We know that there are terrorists. That person is the source of information for future protection. The consequence of having this person identified for deportation is not that he's going to go to jail, so it's not a criminal case, and the right of confrontation technically does not apply. Deportation proceedings are technically a civil prosecution. What is wrong with the balance where there is a summary which can be challenged by the lawyer for the alien who's subject to deportation when you're weighing it against the harm of the many deaths for the Trade Center bombing, when you're weighing it against the need to keep confidentiality for a source that may identify other terrorists, and where you have the consequence, which is not a criminal consequence of a jail sentence, but is deportation?
Senator, it's true that deportation is not a criminal punishment, but it may deprive an alien, as Justice Brandeis said long ago, of all that makes life worth living. It's a pretty serious thing. If you've lived in this country for a long time, married to an American, American children, and you are suddenly sent away somewhere, and without any opportunity to cross-examine your accusers. It's just that I've had a lot of experience of intelligence agencies insisting that they had reliable sources who could not be identified. And when, in fact, the courts required them to be identified, they disappeared in a puff of smoke. They weren't reliable. They had mixed up the names. It happens all the time. And you know it happens all the time. It's not, that's why we have, you know, the greatest engine for the truth, cross-examination. And Lord knows I don't have to tell you that. You were a pretty successful district attorney at using cross-examination. You wouldn't have liked it if you hadn't been allowed to find out the witnesses on the other side.
Well, Mr. Lewis, I agree with you when Justice Brandeis says that if you deport someone, you're taking away a great many of the things that make life worth living, but where you have the threat of terrorist bombings and death to people, you are going further than taking away the things that make life worth living, you're taking away their life. So we're faced with a balance, and I'm trying to craft one. And I'm not saying that because you're elected to the United States Senate, you have any special expertise on crafting the balance. Maybe that's a sign you don't have any expertise if you can get elected to the Senate.
Senator, let me ask one specific question to get off the alien deportation point, because as Professor Cole mentioned earlier, this bill does a lot to American citizens as well. We've all talked about Hamas in a hospital, which is a rather agitating situation. Let's go back and talk about the African National Congress and Mr. Mandela. For many years, for 20 or 30 years, the South African government in the apartheid years referred to the ANC as a terrorist organization, and some American administrations were sympathetic to that view, and they did commit some terrorist acts. That's true. But they were also, as we now know, and as many said then, the principal political opposition, those suppressed. A lot of Americans went to cocktail parties and gave $10 to the ANC. Under this legislation, they would go to prison for up to 10 years. Does that make sense to you?
Well, Mr. Lewis, I don't think that they would, but if they did, they shouldn't. I'm not going to defend that. That's a provision which I would not defend.
My question is, do you want to have a system in which the President of the United States is allowed to designate the ANC as a terrorist organization and thereby make it a serious crime to give $10 to it? I think that's a dangerous step.
I might prefer, under these circumstances, to have the Secretary of State do it than to have this president do it. But I would disagree with what Professor Cole has said, that the Secretary of State's designation is not subject to judicial review. This is not a matter of a foreign policy judgment, which is going to be outside the purview of judicial review. This is a determination that you have a terrorist organization. And I think that a federal judge with life tenure, appointed by President Clinton, so you know he's a fair-minded judge, is going to give a fair consideration to that.
The difficulty, Senator, of course, I repeat, nobody has more respect for federal judges than I do. But if you have something that is so non-judicial in its character, the Secretary of State, suppose that your view were the law and it was the Secretary instead of the President. And the Secretary says, with all our vast resources, we have found that the ANC is a terrorist organization for the following reasons of state and foreign policy. Judges are not familiar with that material, and they're going to be very reluctant to interfere with the judgment. Very reluctant.
Mr. Lewis, what we're really looking at are terrorist organizations that are directing their terrorist activities to the United States.
That's not what the bill says.
Well, it may well be that that bill is not perfect. There's going to be changed yet. It yet has to go through the House. It yet has to go through conference. And that's one of the reasons I'm interested in talking to you about it, because we can use some further insight on it. I think the core provision of the bill is the one relating to terrorist activities where there is cause to believe the person is about to blow up a big building like the Trade Center. And in that context, what I really focus on, and that was the focus of the debate and the focus of my concern, and as the congressional record will show, I went into this issue about confrontation at great length to try to structure something that made sense, and finally came to the compromise about having the summary of the testimony, which was not in the bill as originally outlined, and was prepared to settle for that. And it was settling not for what I really would have liked, but on the analysis and recognition of the people who are inside, who may provide other very valuable information. Now, it is true it could be abused. We've had a lot of abuse. We've had abuse at Waco. We've had abuse at Ruby Ridge. And I'm pressing to hold people accountable at the highest levels. And we're doing things in the Intelligence Committee today, looking at Guatemala, very concerned about human rights. But I think we have to offset the possibility of abuses, which we can't eliminate totally, with some reasonable mechanism to get at terrorists who are planning to blow up American buildings.
But Senator, my first answer to that is that, of course, we all want to not let terrorists blow up American buildings. You know there's no difference between us on that.
I think you and I might not be too far apart.
No, I don't think so. But I believe, and in fact I'm confident, that under existing law, the FBI and the Justice Department can act against someone it has reason to believe is planning to blow up the World Trade Center. I have no doubt of that.
Well, you're not correct about that. I would disagree with you there, Mr. Lewis. There may not be sufficient evidence to bring a criminal prosecution, but there is sufficient evidence to have a deportation proceeding. We're not putting that person in jail for a crime.
Oh, I thought we were still on citizens here. Sorry.
Well, I'm on I'm on aliens, and I'm on an effort to prevent, and I'm on the point of deporting before there's going to be the blowing up of the
In
building.
fact, the INS, what's worrying about the aliens, and here all of us as the children of immigrants need to worry about it, is that their focus has always
I'm
been on...
one of them.
Yes, all of us. I'm including us all. Don't see any Native Americans here.
First generation here, Anthony.
All
We
right, this
don't
is
want
too
focus
amiable.
on
I'm gonna call
political
you off.
activities.
Thank you both. Ms. Toensing and Professor Cole. And Ms. Toensing begins by interrogating Professor Cole.
Professor Cole, if you were on Nightline and said anything untoward, I don't know about it. So I'm just going to have to resort to these few questions I've jotted out here. Let's talk about wiretapping for a moment. And one of as I understand it, your group opposes is this roving wiretap provisions. And for the benefit of everyone listening, it means that instead of just having a wiretap for a particular phone, it follows the person from wherever the person goes. Up until now, the law says that the wiretap has to be for a particular person's telephone, just for your one telephone, Michael. Now, back in the 60s, when the law was written, we all had just one telephone. It had 4 digits, as those were fond memories. Now I go from a car phone to my home phone to a fax. I go all over the place, and so does any putative terrorist. What is more invasive of somebody's privacy, to go wherever he or she goes with the phone to the fax, than tapping the one 1960s telephone the person owned?
Well, under current law, it's perfectly permissible for the law enforcement officials to get a roving wiretap if they show that it's necessary. The change that this law makes is that they no longer have to show that it's necessary. So the issue is not whether or not we ought to have roving wiretaps. We already do. The issue is whether the government should make some showing of necessity in advance before getting a roving wiretap.
Professor Cole, you are well aware enough of law enforcement methods to know that that requirement to show that it is necessary just about eradicates the whole ability to go get a roving wiretap. The threshold, the requirement is much too strong. Why would you oppose one where a federal judge would look at the evidence and decide that it was not practical to just have one telephone tapped? Why wouldn't that be enough? This is not the law enforcement agency deciding it. It is a federal judge deciding it.
I guess 2 points in response to that. One is I see no evidence that it was not possible to get a roving wiretap by showing necessity in the past. And I think the best evidence for that is that the FBI has not sought this authority with respect to any other kinds of crimes, very serious crimes. It hasn't sought that authority. Roving wiretaps it uses, and it's able to use them. So I don't see the evidence, number one. Number two, the real problem
If I gave you some evidence from my days in the Justice
No.
Department when we had to take down a tap during the hostage-taking of
I'd like to,
TWA 847,
I'd like to conclude my response. Number two, I think the real problem with the wiretap consequences of this bill is not the wiretapping provisions themselves, but the provisions that make it a crime to provide support, lawful support, a nonviolent support, charitable support to any organization that the president designates as terrorist. What that means is that
Did you just change the subject?
No, because what that means is that we are now making a crime of lawful political opposition, and that means that the FBI will be justified, indeed the FBI will be mandated to put wiretaps on groups that are doing nothing more than the political domestic solidarity work. And the concern I have...
We're going to stipulate, Professor Cole, that I'm against the fundraising, which is...
But see, you can't treat them separately because you can't treat them separately
But I want
because
to
once
ask
you
about the
make
wiretapping for the bombing, because that is really what we're talking about. And I am talking about a personal experience at the Justice Department where we had to take down a wiretap because we were not allowed to use it during the TWA 847. We had a problem because the people who we felt had information, we had a tap up, we felt had information about where the hostages were being kept in Lebanon, were changing from telephone to telephone. These people get smart. They hear that you can't tap one phone after another, and so they continue to change the phone. I'm talking about the Puerto Rican macheteros who went from telephone to telephone, left their apartments to make telephone calls as they did. They were on that graph. They were the ones that were way up there, the Puerto Ricans, terrorists.
I think that
you can answer that question.
You can answer
the
it.
offensive.
I think the response is that technology is available to everybody. The FBI has never claimed that it needed this authority before. It was only in response to the Oklahoma City bombing that this kind of provision was put forward, and it seems to me it's exploiting the fear that was caused by that bombing. The question I have is, goes back to first principles. Justice Brandeis, in one of the cornerstones of First Amendment jurisprudence, said that the theory of the First Amendment is that the path to safety lies in a free and open society where people are free to engage in political opposition activities. That when we repress legitimate political opposition, nonviolent political opposition, when we make it a crime to engage in lawful associational activities, we encourage people to go underground. We make it harder to find out what's going on, and we specifically encourage people to take violent measures.
Do you want to know if I agree with that statement?
It seems to me that the reason that we in the United States have been relatively free of terrorism is precisely because we are a free and open society where people know that they're going to have the evidence presented to them, where people know that they can engage in political activity. It's the repressive societies of this world that incur the most violence, the most political violence, the most terrorism. So isn't this entire bill really a mistake, because it's going to encourage terrorism, not deter terrorism, by making lawful political activity a crime, and then by making people have to fear the use of secret evidence against them?
Actually, Professor Cole, this bill is not going to encourage terrorism, but let me address your statement about an open...
Justice Brandeis was wrong.
No, he had a wonderful statement. He just wasn't making it today in the context of what's going on. And from my experience at the Justice Department, why were terrorist attacks not coming into the United States? Because terrorists were afraid to come here because they thought they would be caught. That was the intelligence information we got. Why were all the terrorist attacks in the 1980s directed at Americans abroad? Because they thought they had it easy when they were doing it in Lebanon, in Greece, in the other countries that they didn't think were going to be as tough to catch terrorists. And it was one of our formats, one of our policy formats in the 1980s to bring in other countries, to have other countries agree that they should also prosecute terrorists on the same level that the United States was committed to doing so. What's happened in the 1990s is that a few terrorist organizations have figured out that they can get over here and they can infiltrate some areas and they can plant bombs in the World Trade Center. And it's our reaction to that you are seeing in this legislation, because now we are seeing terrorists come across our borders where we had not seen it before, except in Puerto Rico.
But the problem, it seems to me the problem is that the problems that we are seeing in terms of the World Trade Center, and the World Trade Center bombing was obviously a terrible incident. There have not been a lot of World Trade Center bombings or anything close to a lot of World Trade Center bombings. The problem is that we respond quickly, we respond exploitatively, and the first thing we do is we tramp down on people's civil rights. And whose rights do we trample down on first? Immigrants. Immigrants get it worst under this bill, and then U.S. citizens. And I think what that demonstrates is that there's a slippery slope here. And although the targets of this bill today will most assuredly be Arab immigrants, just as they have been for the last 10 years, tomorrow they may be an entirely different group. 10 years ago, the target would have been Irish people who are supporting the African National Congress, people in the Central American Solidarity Movement. Tomorrow, who knows? The point is that we have a First Amendment and we have a due process clause to ensure that the government does not overstep its bounds, and we don't have to fear our government more than we fear criminals.
I said earlier that when we had written this legislation, the removal of alien terrorists, I had said it's going to take some people to be killed in order to get this passed. And that, unfortunately, is the way our system works. I can tell you that we did the background.
It doesn't matter who's killed or what they're killed by.
No, it matters a lot.
Because,
let me finish.
it's the Oklahoma City bombing.
Please.
Mr. Cole.
Let me finish. That bill was researched, and the constitutionality of it was researched in the quiet of the 1980s. Unfortunately, in order to get Congress to act, and Senator, I'm sure you'll agree with me on this, it takes some kind of outrageous act of conduct in order for them to be mobilized to pass legislation such as this. And what the government does is it then begins to push this kind of legislation when that occurs.
Thank you very much, both of you. Mr. Glasser, it's time for your closing arguments. And I've got to hold you to 2 minutes, I'm afraid.
Okay. When Mr. Lewis posed the question to Senator Specter about why, under this bill, would you want to make it a crime for someone to have gone to a cocktail party some years ago and given $10 to the African National Congress, Senator Specter said he couldn't defend that. But you did vote for the bill that allowed precisely that. And that is what the issue is here. The issue is whether or not we are in a period of hysteria over Oklahoma City and the World Trade Center, which is causing us to go after people not on the basis of criminal activity, but on the basis of our fears related to their national origin or their political beliefs, or whether we have enough legislation to go after the people who are actually committing terrorist crimes. Nothing that happened in Oklahoma City, nothing that happened in the World Trade Center is permissible now. All of it is illegal. The government can investigate all of it, but it has to have some reason to believe that it's going on. It can't use as a proxy somebody's national origin. When we did that, you know, the day after Pearl Harbor, we were in much worse shape than the day after Oklahoma City. And what did we do? We got so terrified, the very same arguments that some of you were making today. We can't take the chance. Why wait to the last minute? After all, you know, they all have relatives there. The same kind of arguments. Don't wait for evidence of a crime. It'll be too late if you wait for evidence of a crime. What's reasonable? So what we did is we went out and we arrested 100,000 of our own citizens because of the color of their skin and the nature, the national origin. We put them in prison. The courts did not exercise any judicial review. They rolled over and played dead because they always do in areas of national security. It's naive to suggest otherwise. Nothing in our history suggests that the courts could interpose themselves under those circumstances. And now everybody knows it was the most grievous mistake we ever made. President Reagan in 1988 said that was an act of war hysteria and racism. It would have been nice if he had said it in 1942. We said it in 1942. Everybody thought we were treasonous. For once, let's say it when it counts. Let's not overreact. We have the laws we need to go after the people who commit terrorist crimes. We don't need to go after the people who are not committing crimes because of our fear about what they think or who they are.
Thank you, Mr. Glasser.
Mr. Chairman, we got here a problem of perspectives. We've heard a lot of talk about Mandela, and look what we would have done to Mandela if we had taken him seriously. Well, the answer is he was a terrorist, and he prevailed. Nothing works better than for a terrorist government to prevail. It happened in Israel. It just now happened in Vietnam. If it happened in Sri Lanka, it's happened in Algeria. If the rebels in Sri Lanka prevail, well, they'll be invited to the White House in due course. The history is the polemic of the victor, as has so often been pointed out. But we're talking about what do we do if they don't prevail? After all, Washington was a terrorist also, wasn't he? He would have been hanged if he had been caught. The point is not who is going to prevail, but what is the relevant perspective? Jerry Adams was denied 8 times a visa to the United States. Nobody questioned the right to deny him that visa because he is the political spokesman of the IRA. So finally, diplomacy takes a turn and says, okay, let's invite him over and see what happens. Well, he didn't choose this moment to kill anybody. But the fact of the matter is that nobody denies that he had the authority to be held out. An act of terrorism was committed in Dallas on the 22nd November, 1963. And when Hoover was asked why wasn't Lee Harvey Oswald kept away from or detained in some place or another, because indeed he had been very active in a pro-Castro front, Hoover said, if I had to detain everybody using that threshold of security risk, I would have to pull 40,000 people away when the president visits Chicago. So there are real limits, real problems. But the perspective is There are people engaged in activity which ends in explosions of the kind we had in the World Trade Center and we had in Omaha, and we had in Oklahoma. These are people who's with fire in their belly, who wish to accomplish their political ends, and we as a free and deliberative society ought to sit down and reason as they did in the Senate. The fact that 91 senators out of 100, many of them lawyers, thought this urgent enough to endorse strikes me as presumptive suggestion that they seriously understood the differences between simply normal quotidian acceptance of terrorists and the special nature of their reach today. So I want you to vote for the bill.
Thank you very much, Mr. Buckley. Well, I'm afraid our debaters have done a magnificent job, but they've totally used up the time, and my brilliant summary and conclusion about whether I will support this bill or not will have to be off the record or in a deep background. Thank you very much to the debaters. Thank you to George Washington University, and congratulations again on your 175th anniversary. Thank you all of our viewers for watching. Thank you and good night.
This program was a Warren Steibel production in association with South Carolina ETV. Funding for this firing line debate was made possible by a grant from the John M. Olin Foundation, Incorporated, the Annenberg Foundation, and the Laurel Foundation. For a video cassette of this 2-hour debate, send $49.50 to Firing Line, 2700 Cypress Street, Columbia, South Carolina, 29205. State the subject of the debate and please allow 3 weeks for delivery.
This is PBS.
For a transcript of this 2-hour debate, send $10 to Firing Line, 2700 Cypress Street, Columbia, South Carolina, 29205. State the subject of the program and please allow 3 weeks for delivery.